Please share the link to the live stream, please.
Sawa sawa.
Mkutano umeanza, tuko hapa online. Mkutano uko hapa online.
Good afternoon, participants. Welcome to today's webinar. This has been a series that has been running for quite some time. We've been looking at the Children Act 2022, which is one of the most recent acts. And this is part 4 of the series. We've in the past had, the first one was generally just unpacking the act, looking at its highlights, looking at what are the changes when comparing the 2001 Act and the 2022 Act. Then we had a second webinar where we had Senior Counsel Chigiti guide us through the topic of intersex children, looking at their rights. And we must appreciate that it's such a milestone where we are having recognition of intersex persons in Kenya. So that was the second one. Then the last one that we had was on children, that was guided by Advocate Abegi, was on children in conflict with the law, where we covered also diversion and children in need of care and protection. So it being the fourth, still looking at the Children Act 2022, We're going to be joined by two of our speakers who've already joined us, Madam Jennifer Kaberi and Anne Thiongo, who I have been privileged to work with in the child protection sector. We're going to know much about them after our official welcoming note by Madam Namisi, who is the LSK Nairobi branch chairperson. Karibu sana, Chair.
Good afternoon, ladies. Good afternoon, ladies and gentlemen. My name is Helen Namisi. I'm the chair of LSK Nairobi branch. Thank you very much, Joy, who did not introduce herself. That is Joy Katunge, who happens to be one of the council members. So, ladies and gentlemen, on behalf of the branch, we'd like to welcome you to today's session, which is the final one in the series that we have been deliberating on, which is the Children Act 2022. As Joy said, this is a fairly recent legislation. And as practitioners in this area, it's important for us to keep abreast with the changes that are happening, what is new in this particular legislation, what we need to look out for as we continue to practice in this area. This afternoon, we're quite privileged to have two ladies. Previously, we had two gentlemen. We have two ladies this afternoon who are going to be talking to us about protecting our children in the online space. We realize that our children are quite exposed when it comes to online activity. They are able to access the internet from whichever device, whether it is our phones, our tablets, iPads, even television. So they're able to access a lot of information that may be good or also negative towards their well-being. And so it's important for us as practitioners in this area and parents to be able to understand how can we protect our children in this online space in light of the provisions of the new act. And so with that, ladies and gentlemen, I want to say karibuni sana. I hope that we all gain something useful this afternoon. Please feel free to interact with the speakers that we have. Your moderator will be able to guide you. Thank you once again, Joy. And I hope that we shall have learned something very useful by the end of this session. Having said that, please feel free to reach out to the branch using our various social media platforms. You can reach us on email, on phone, as I said, on social media. Please reach out, let us know what you would like to hear more about. Let us know how we can address some of your concerns, practice concerns, and welfare needs. With that, ladies and gentlemen, karibuni, have a pleasant afternoon. Back to you, Joy.
Thank you so much, Chair. I always often forget to introduce myself because one, I think I know a lot of people, but that's not an excuse. So my name is Joy Katunge Matheka. I am an advocate and serving the branch as a council member. I also work for an NGO known as Kenya Alliance for the Advancement of Children, where I've been able to interact with Anne Thiongo, one of our speakers, as well as Jennifer Kaberi. And I'd like to welcome you again because I can see the numbers still trickling in. A reminder as we start off, kindly use the chat box. We encourage you to use the chat box to seek clarity, to ask questions. Kindly use the chat box. And towards the end of the session, we're going to be having our speakers address your questions. So without much ado, allow me to introduce our first speaker, Madam Annie Thiongo. Anne Thiongo is an assistant director of children's services in the Directorate of Children's Services. She's a holder of bachelor's degree in social science and a master's in public administration from the University of Nairobi. She handles access to justice for children docket in the Directorate of Children's Services at the headquarters. So when you hear me say DCS, that's the Directorate of Children's Services. She has a special interest in children in the justice system, whether as child victims or as children in conflict with the law. In an effort to improve access to justice for children, with the support of U.S. Embassy Department for Justice, coordinated a virtual training of over 400 children officers from the Directorate of Children's Services this year on the topics on bail and bond, plea bargaining, diversion, and active case management, where key stakeholders in the child justice system facilitated. She's been a long-standing and active member of the National Council on the Administration of Justice, that is the NCAJ, Special Task Force on Children Matters, and the National Standing Court Users Committees, that's the CUCs. She will be taking us through safeguards for the rights and the best interest of the child. Karibu sana Ann Thiongo. We are ready to hear from you.
Thank you very much, Joy. Thank you for that introduction. It's indeed a pleasure to listen to you this afternoon. Thank you very much, Helen Namisi, the Nairobi branch chairman. I'm indeed delighted to be part of this session this afternoon as we go through the Children's Act, the act which advances the concept of the best interest of the child and is paramount to the consideration in every matter or decision concerning the child. So without further ado, allow me to bring in my presentation. Thank you. Sorry, I didn't realize I was muted. Joy?
Sorry, Annie, you're muted? We can hear you, we can hear you.
Oh, you can hear me?
Yes.
So that means you missed my remarks after you spoke?
No, I heard you.
You heard me. Okay, fine.
Yes.
I want to put this on slideshow. If you could just give me a few minutes. I don't know whether, Joy, you can assist to have me have a full screen.
When you slide show, you have a full screen.
Yes, and I'm there. I don't know what's happening. Okay. Yeah,
Good.
I think that's
Perfect.
That's okay now.
Yes, go on.
So my role this afternoon is to take you through the Children's Act Part 2. It contains the safeguards for the rights and best interests of the child. This is quite a lengthy session or section, so you'll allow me not to go through every part. I have made an attempt to pick what I thought was key. So that should take us about 40 minutes from now. I'm having a problem moving my slides, Joy. I don't know whether you have my slides to help me move.
Unfortunately not.
Yes.
Yes.
Okay. So there we are. So for the first time, we have the Children's Act defined by the Children's Act 2022. We are all aware that in the repealed act, there was no definition. The definition speaks to the survival, the protection, participation, and development of the children. And that is also mentioned in Article 53, Sub-Article 1 of the Constitution, in Section 8. I have something here that is blocking my view. I don't know how we'll proceed with this, but that is the Children's Act of 2022. But we know as child practitioners, whenever we go to court or whenever we are looking at children or every time we are dealing with children, we will always look at the best interest of the child. You now see from the definition, it talks about the survival, it talks about the protection, it talks about the participation and the development of the child. All this encompassed in the best interests of the child, the pillars of the best interest of the child in the UNCRC. Section 8 of the Constitution of the Children's Act, talks about the best interest of the child shall be the primary consideration. The best interest of the child shall include, but not limited to, the considerations set out in the first schedule. The first schedule looks at the assessment of children in conflict with the law, but I'll not go into that. So what is meant by the best interest of the child? Globally, there is no standard definition, but when the courts are serving the children, they'll look at the services, they'll look at the actions, and whatever else is in the best interest of the child. The overall theme of the principle is that due focus and priorities should be given to the child whenever policies, laws, and decisions which directly affect the child are looked into. This means that the state has a role in the best interests of the child. They must come up with policies, they must come up with laws, they must look into the best interests of the child. But universally, there are certain minimum requirements that have universally been accepted. We know there's a right to shelter, there's a right to food, there's a right to education. A child is entitled to medical care, and the child's welfare should be taken care of under the best possible circumstances. The principle of the best interest of the child is a key concept in the world of the child. It mainly applies in the realm of family disputes, such as custody, where parents could have been separated, guardianship, maintenance, adoption, and every other action. But you now see, or rather originally, the doctrine of the best interest of the child was limited to this application. This was mainly applied on issues of divorce or custody. But with time, we have seen that the principle has now been extended to apply not only in its original sense, but also in relation to all actions concerning the child. So we're not just looking at custody, we're not just looking at guardianship or maintenance or adoption, but this has now been prudent so that at any one time that you're dealing with a child, you're looking at the very best interest of that child. The best interest of the child was discussed during the 1924 Geneva Declaration on the Rights of the Child. It was further discussed in 1959 during the UN Declaration on the Rights of the Child. It's the cornerstone of the UNCRC of 1989 and also the Africa Charter on the Rights and Welfare of the Child of 1990. And from the Geneva Declaration, we see the rights of the child was based on mankind owes to the child the best it has to give. I came across this and I saw there's the paramount consideration and there's the primary consideration. And I realized, or if you go through that article, you realize that during the UNCRC in 1989, there was a very big debate. Are we looking at the primary consideration or are we looking at the paramount consideration? The delegates felt the paramount was too broad. Therefore, ultimately, the best interest of the child should be the primary consideration. So we don't look at the very broad interest of the children, but what is the primary consideration of the child. And this reminds me of an article that appeared last week on Friday in the Daily Nation. That's 16th of September, where there's the father and there's the mother and there's a child who is 16 years old. So the case started when the woman moved to Mombasa, to Nonoka Children's Court, seeking orders that the child be allowed to travel to UK to join college for a 2-year program. She said the father failed to help the child with documentation because the child needed a visa to travel to the UK, and also the college required some documentation. But the father refused to submit those. And that being the case, the mother moved to the court. She asked for the court's intervention. The father insisted the background of the person sponsoring the minor was not known to him and was not clear to him. He said it was not safe for the child to travel outside the country. He further lamented that he had been denied access to the child for the past 1 year. After hearing both sides, of the parties, the principal magistrate, Madam Yator, ruled in favor of the woman, noting it was in the best interest of the child that she travels to the UK to pursue her studies. The father, of course, was very aggrieved, very dissatisfied. He moved the family court on appeal. His grounds of appeal having been, he's been paying school fees, he'll be denied parental care and custody, and was not allowed and was not consulted when the scholarship was being sought. His questions were, who is the child traveling with? Where will she stay? So according to him, those were his interests. The judge therein ruled throughout the appeal, noting having acquired a 10 million scholarship, it would be prejudicial to stop the minor from pursuing further studies. So in this case, and I think to me this is a very good example of a best interest of the child. In this case, we see several interests fronted by the father. The safety of the child when traveling, who will the child be living with? He also looks at his interests, I don't call them his interests. He will be denied custody, the child will lack parental care, and so on and so forth. But at the end of it, Justice Oyego said the best interest of the child is paramount, superior to that of the parents, and it cannot be compromised even in the absence of consultation between parties. So in this case, the child was allowed to proceed because that was the primary interest for the child, best interest of the child. I hope I have demonstrated that example good enough. We have several articles that speak to the best interest of the child. That is Article 3, where it talks about children should be at the forefront in the situation of adoption, detention, custody, disputes among parents. Article 18 speaks to both the father and the mother have a common responsibility in the upbringing and responsibility of the child. This has been carried again to the Children's Act of 2022. Article 20 deals with the situation of a child who's temporarily or permanently deprived of his or her family environment. Article 21 means the state should use all possible means to ensure that before it grants a child for adoption, that they have checked and seen it is best fit for that child to be with that person. So the UNCRC, again, we have section 37, which deals with the children in conflict with the law. And in criminal cases, the best interest principle applies to children in conflict or alleged, accused, or recognized as having infringed the law. We must deal with these children through rehabilitation or restorative justice and not repression or retribution. And if you look at section 233 of the Children's Act, it gives effect to that article where it talks about children in conflict with the law when they're going through trial. Is it reasonable for them to be placed in alternative placement for those children? Article 53 again speaks to that, where you talk about detention as a means of last resort. Then we have Article 3 and 4. Again, this speaks on the African Charter on the Rights and Welfare of the Child, and this recognizes that other interests can be considered, but the child's interest is of most importance. So you see then, the best interest of the child comes all the way from the UNCRC to the African Charter on the Rights and Welfare of the Child. We will see it is also there in the Constitution. We will see it is also there in the Children's Act. So the best interests of the child are further enshrined in Article 53. I think I've spoken to that. Sub-Article 2 of the same article. A child's best interests are of paramount importance in every matter concerning the child. So now when you go to the Children's Act, we have section 6, subsection 1, every child shall have a right to life, survival, well-being, protection, and development. This is not so much of a departure from the repealed act. It was there, and you see it again in this same act. Section 6, subsection 2 of the act, no court shall pass a death sentence for any offense committed by a child. So we are saying that when a child commits an offense, regardless of how grievous or how big the magnitude of that offense, the child should not be committed to death. That is also emphasized in section 238, subsection 2, that says, notwithstanding the nature of any offense punishable by death, You shall not punish that child by death. No court shall impose the death penalty on a child or a finding of guilty for such an offense. But we see again in section 238, subsection 2, it gives us all those, section 239 goes on to show how best we could deal with that child who has committed that offense. So we are saying you cannot commit that child to death, but there are all those ways or methods you could deal with that child. Then we have section 7. Every child has a right to a name and nationality and has a right to be cared for by their parents. Again, this is not a very big departure from the repealed act, but we are saying that for every child, they have a right to a name upon birth and they have a right to a nationality. Excuse me. Section 7, subsection 2 of the act. Every child has a right to be registered in the Register of Birth after birth in accordance with the Birth and Registration Act. So for this is this was not in the repealed act, but now we are saying that all children must be registered by the Registrar of Births and Deaths. I know it is there in Cap 149 of the Registrar of, in the legislation of births and deaths, but it was not there in the act. So we're now saying that it is a requirement in the act, it has been put there, it is there in law, that children must be registered upon birth. Section 7, subsection 3, the principal registrar shall take measures to ensure correct documentation and registration of intersex children at birth. This is certainly a new thing. It was not there in the repealed act. The repealed act did not recognize intersex persons, but now the principal registrar has to ensure that intersex children, they acquire the proper documentation. We are all aware that today, if a mother gives birth to a child, you get a notification. The notification only has 2 categories, male or female. Further on, if you go to acquire a birth certificate, there are only 2 categories, male or female. But now we are saying, or the law is saying that the principal registrar has to ensure there's a category of intersex children. This would be an interesting thing to see, but we really appreciate that the principle that this has found itself in law. This is because these children have been discriminated, which is a violation of their rights. Other safeguards, a child found in Kenya who appears to be less than 8 years must have a nationality and the parents must be known to him and shall be presumed to be a citizen by birth. This again was in the repealed act, but we're now saying, or rather what this law is saying is that children who probably find themselves on Kenyan soil, they're 1 year, they've been abandoned, they're 6 months, they're 2 days, they shall acquire the nationality of Kenyan citizens and they must be given a name. That is for all children who are below 8 years. Section 8, in all actions concerning children, whether undertaken by public or private welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. So shall is a very strong word because it gives the state the duty to look into the best interest of the child. The best interest of the child shall include and not limited to the considerations of the first schedule. The first schedule of the Act talks about assessment of children in conflict with the law. Moving on, then we have separation of children from parents. This was not well expounded in the repealed act, but we are saying section 11, subsection 1, every child has a right to care and protection. The dictates of these sections that exceptions are provided where a child may be separated from parents, where the court or the secretary here means the Secretary of Children Affairs, determines that the separation is in the best interest of the child. And the best example I could give is where a child has been defiled, say by the father, or even gone through physical abuse by the mother. So, and probably this matter is in court, the child needs to give evidence, the child is a victim and is awaiting to give evidence. The Witness Protection Act the witness protection agencies may remove that child, or the court can give orders to have that child removed from the home because it is in the best interest of that child to be removed from the home. But now again, Section 11, subsection 5 of the same act goes to say that where there are siblings, 2 or more siblings, it is in the best interest to keep those children together unless there are compelling reasons which shall be determined by the court. Because we know sometimes there are 3 children or there are 2 children, they are of different ages. One could be 12 years, the other one could be 3 years, or the other one could be 5 years. And if those children have to be removed from a home and they have to be taken, for example, to a charitable children institution, because of the age difference, one charitable children institution may not be able to take the 2 siblings, because maybe one charitable children institution is only able to take children from 0 to 10, and another one from 10 to 15. So you find sometimes it is not possible to take all those children into the same institution. But where possible, it is encouraged by the law that we should not separate siblings. Then there is the right to social security. Social security was not fully provided for in the repealed act, though it was practiced. This gives effect to Article 43, that the state shall provide appropriate social security to children who are unable to support themselves and their supporters. So where children are in a family home and the parents or the primary caregiver is not able to support those children, then the state is obligated to probably remove those children from the home or to provide for them in one way or the other. So borrowing from the UNCRC, all efforts need to be made to support families to continue taking care of their children. If that is not possible, place the child in a family-based care arrangement. So they should not look like they have nowhere to go. The state is obligated to take care of them. So those are the alternatives where we could place children who need social security. This is provided for in Section 12, subsection 2 of the Act. We have kinship care, means the adoption of a child by a person who is the relative of the child. So you could take in your niece, you could take in your nephew, you could take in your grandchild. That is what we call kinship care. There's some blood relation. But there are 2 types of kinship care. One is informal, where a child is looked after on a long or short-term basis by his or her extended family. Then we have the formal kinship care, where a child is taken care of on a long-term or short-term basis by an extended family following an order made through judicial authority. So in the second one, which is formal, we must go through the courts. There must be an order made by the court. Then we have guardianship. This was provided for in the repealed act, is one who is appointed by will or deed by the parent or order of the court to assume parental responsibility of a child upon death. So anybody can move to court and say, upon death, my child will be taken care of so-and-so. That can be done by will or by deed, where the court appoints that person to assume parental responsibility in the event of death. We also have foster care, where there's temporary placement of a child who's not a parent, relative, or guardian, so there's no blood relation. There's adoption. This was certainly in the repealed act. There's a process through which a child is permanently placed by a legal parent or is adopted because of the situation that it is. This, I think we're all aware, is permanent and is not reversible. And the child who's adopted acquires all rights that any other child born in that home would acquire. That means they are allowed to inherit, and that is by law. Then we have kafala. This is practiced under the Islamic faith, taking in a child who's deprived of parental and family care. So one would have to be a Muslim to practice this. This was being practiced earlier, but now it has found itself here. But even when we had the repealed act, this has been highly practiced, just so that we move our children from institutions and bring them up in family homes. Then there's care for children in emergencies. There should be guiding principles on how to provide family-based care for children in the event of natural or human-made emergencies. That was not there in the repealed act, but now we see that we should have principles on how to take care of these children in case we have an emergency. Then we have supported, okay, rather temporary shelter. This again, sometimes we may have to put children at a temporary shelter, and that again is just temporary, it is not permanent. We have supported independent living, where a young person is supported in his or her home or other accommodation to be independent. So it's a child who is supported to be independent. Then we have supported child-headed households. This came about especially when we had the HIV/AIDS pandemic, where children lost their parents and they found themselves with other siblings, with other children in a home. So this is where a child assumes the primary responsibility for the day-to-day running of the household. The children may be related or may not be related. So you have seen about the cash transfer program. The government has been very instrumental in that. They give 2,000 per month. So even for a child who's heading a household, they're entitled to the 2,000 per month just for them to continue their day-to-day living. Then we have institutional care. This could be statutory or charitable children institutions. For statutory, we have the rescue centers. We have about 5 rescue centers. This is not for a child who has committed any offense, but this is a child who could be abandoned, a child who's lost, a child who has been neglected, could be placed in that home. A child will also be placed in a remand home as they are going through trial. The case is in court and they're going through trial. And for some reason, one way or the other, they're not able to acquire bail or bond, so we'll hold them in that institution. As a Directorate of Children's Services, we have 14 children remand homes spread across the country. Then we have rehabilitation schools. This is where children are placed after they have gone through trial and they have found to have committed an offense. So the court sends them there. It's a way of rehabilitating them, and they are sent there for a period of 3 months. Then we have aftercare. This is a process where a variety of services are offered to children after they leave alternative care and move on to be independent living or reunified with their parents. As a directorate, we have developed guidelines on alternative family care of children, so I invite you to look at them. This is well expanded, and there's much more that is in those guidelines. Thank you. Section 8 talks about child labor. This is not a very big departure from what is in the repealed act, but we now see the Cabinet Secretary has been obligated to make regulations for children who have attained the age of 13, but have not attained the age of 16. So that is one category. There's also the other category of children who have attained the age of 16, but have not attained the age of, the children who have attained the age of 16, but have not attained the age of 18. This, I believe, is in line with the ILO Convention 138, which states that states must dictate at what age children are entitled to be employed. So we wait to see about these regulations and what will come out of them. Then we have the intersex child. This is being defined for the first time. Like I said, intersex children were not recognized in the Children's Act. They were not recognized anywhere. That is a definition of what an intersex child is. I know it looks a bit too technical, but in layman's language, an intersex child is one who is born of both organs. So you cannot specifically say this is a male or this is a female. So the Act has gone on to talk about the intersex child and provided there are sections that provide for the intersex child. For those of us who had the privilege of listening to Senior Counsel Chigiti a few weeks ago, he took us through the journey of what it has taken the intersex child to be recognized in the Children's Act. And we sincerely applaud him for the work that he has done. He informed us that there was failure by the legislation of Registrar of Births and Deaths, Cap 149, to recognize the intersex persons. Like I said earlier, these children have been violated, their rights have been violated, they were not recognized anywhere, and therefore their rights were violated. He told us that there were deliberate efforts were made from 2007 to ensure this special group enjoyed the rights like any other child or like any other person. He further informed us, and I hope I will not be accused of plagiarism, that in 2013, a petition was filed under public interest litigation for an intersex child who he called BBA. The act discriminated the special category of children, like I've just stated, but now we see there's a definition, and the law now recognizes the intersex child. So there is section 21, which talks about medical treatment, education, training, and that speaks to the Universal Declaration, the UN Declaration on Human Rights, and further gives effect to Article 28 and 43 of the Constitution. Article 23, let me just go through it. Every person has inherent dignity and the right to have the dignity respected and protected. So there was no dignity that was provided to those children. And then Article 43 gives every person economic and social rights. So Section 23, subsection 3, recognizes both male, female, and intersex children. For those who liberty shall be accommodated in separate facilities. So we're saying that for children who may be in conflict with the law, we are now recognizing that we have the male, we have the female, and we have intersex children. Then we look at section 63 of the Children's Act, and or rather 64, the Inspector General now has been mandated to establish child protection units. Child protection units are those units where if a child commits an offense, instead of putting them in the cell, we put them in a child protection unit. So the law now recognizes that, and section 64, subsection 3 of the Act says the child protection units established under subsection 1 shall be desegregated by gender with clear sections for boys, girls, and intersex children. So the IG there has a mandate that when he puts up child protection units, which is supposed to establish in every police station, there shall be clear sections for both girls and intersex children. This is so because intersex children have committed an offense, they are put in the cell for girls or they are put in the cell for boys, but they are neither male or female. So that again takes recognition of that. Section 23, subsection 1F, no person shall subject a child to, except with the advice of a medical genetician, organ change or removal in case of an intersex child. This, I believe, was brought in here because we have seen children who are intersex, and then the family maybe goes to change to have one organ removed, so the person becomes a boy. And as the child grows, they develop hormones of a girl. So then there's that complication. So now the law has protected those children, and you cannot do that without the medical geneticists for organ change. Section 144 talks about children in need of care and protection. And now we see children in need of care and protection have been included in the category of children in need of care and protection. So intersex children are now are also in need of care and protection because they are likely to be subjected to discrimination in terms of treatment or abuse. And that's indeed a milestone. And we sincerely appreciate what the Act has provided therein. As I come to an end, there's no person who shall subject a male child to forced circumcision. I think as Africans or our culture, we have taken it for granted that boys must be circumcised. But we know sometimes it's done forcefully, sometimes it's done in very unhygienic conditions, and therefore it is important that children therein are protected. And these children should not be forced to be circumcised. So I personally like that. There's the FGM, of course, that was provided in the Repealed Act, and also we have the FGM Act. We have been talking about early marriage. That is no longer the case. We now talk about girl-child marriage, that children should not get married at that age, below 18. Children will not be subjected to virginity testing. That is where sometimes you want to see if the child has had sex, we subject them to virginity testing, and also the girl-child feeding, which has been very common in some of our communities. We find very young girls who have been beaded. This is so because they have been booked, so to speak, are waiting to be married. So now the law protects them. The Children's Act now protects them. We have children deprived of liberty. Children deprived of liberty, detained or held in custody, shall be held separate from adult facilities in transportation facilities appropriate to the special needs. This is not very different from what was there, but now I see there's an inclusion in transportation, because we know sometimes children have been bundled with adults as they're being taken to court and they're being taken to the remand homes. So that has been provided. Then section 26, subsection 3, male, female, and intersex children deprived of liberty shall be accommodated in separate facilities. So again, the law recognizes the intersex child and that they shall be held in separate facilities. I think I am through, and thank you very much for listening to me. I think I'm well within my time. Thank you.
Oh, thank you so much, Anne. Listening to you is such a joy, and just imagining how much information you've had to compress. The Children Act is quite bulky. It has information that you fought for to have it there. I don't want to call it bulky. I'll call it comprehensive. And you've tried to stay within the time allocated to you. I don't know if you'll stay in till the end of the session so that we can take all the questions at a go. Will you be around?
Yes, I'll be around, Joy. Thank you.
Great.
Thank you.
Thank you so much. Thank you so much, Anne.
You're
For those
welcome.
of us who are joining us, that is Anne Thiongo, who was our first presenter for the day. She's taken us through a couple of topics, emphasizing so much on the best interest of the child as enshrined in the Constitution, Article 53. She's spoken about alternative care, laid emphasis on the intersex child. We had a whole session on this, and I love that she gave us a recap. It's such a milestone for us because none of the previous laws on children ever touched on the intersex child. She's spoken about harmful cultural practices, and of interest to me was forceful circumcision. When you talk about harmful cultural practices, we have this bias that it's about the girl child undergoing FGM, early marriage, bleeding, but here's a good and another interesting thing, forceful circumcision. As we keep absorbing the information that we've heard from Anne, I'd like to welcome our next speaker and maybe address some concerns that we have. If you missed the first session of Anne's presentation, kindly visit our Facebook page. I've shared the link. I'll keep sharing the link. You can always watch it in case you can't keep up until the end. You can be sure to catch us on our Facebook page. So our next speaker is a friend, just like Anne, and I mentor in so many ways. And I'll take us through Jennifer Kaberi's profile, which is rather compressed. Jennifer Kaberi is a child development specialist and an international development work professional with a passion for children. Her vision is to transform Africa's story through empowering children to speak for themselves, data-driven solutions, and technology that is Afrocentric. She believes this will result in positive outcome in Africa that touches not only socio-economic development, but also humanity. Jennifer has spent 10 years working in the child development sector on an array of community, district, national, and international projects. In 2017, Jennifer founded Mtoto News, an online platform to improve the lives of children through technology. Mtoto News uses the power of media and data to provide a platform for children to participate in developing solutions to challenges that face them. Jennifer is a Harvard School of Law Fellow at the Institute of Rebooting Social Media, Yali Eastern Africa Fellow. She holds a BA in Sociology and Communication from the University of Nairobi and a Master's in Child Development from Daystar University. Join me in welcoming Jennifer Kaberi. We fondly call her Jenny in the child protection streets. And she's the CEO and founder of Mtoto News. Karibu sana, Jenny.
Asante sana, Katunge. Thank you so much for inviting me. I think Katunge did not mention one thing people know. I'm a dropout of law school. So I'm going to speak on two very new provisions in the new act, something that was not provided for in the previous Children's Act. Okay, and so I want your engagement. So I want to hear from you. So just give me a second. I share my screen. So as Joy said, I am Jennifer Kaberi. I am CEO and founder of Mtoto News and also a member of the National Steering Committee on the implementation of the Children's Act. Initially, it was for the development of the Children's Act. So, but now we have evolved to implementation because now it was enacted. So I'm going to speak on two topics, online safety and child participation. So these provisions were very scanty in the previous Children's Act. So like online safety was not existing then. In 2001, we didn't have online issues, and child participation was just mentioned when it comes to judicial issues, not in all matters. But now there's an expansion on that. So Katunge has already mentioned, I work for Mtoto News, an online platform on news, information, and resources on children. Please go follow us on Twitter, Facebook, and everywhere you are at. So this is a bit interactive. I'm going to request you to put your phones or wherever you are, to your favorite social media platform and post. Please tweet as I speak. That would be interesting. I hope LSK, that is your Twitter handle. So so please just post and let's have an interaction. Let people know about what's going on. So straight to my presentation. So Kenyans are known for social media. Kenyans use 4 hours. Kenyans spend an average of 4 hours, 36 minutes online. That is in 2022. That's not even 2021. That is 2022. This is 2020. Just before there, now this is 2019. So these numbers should have doubled by now because of COVID. Okay, and this is one of the reasons that drove those of us who are working Act to say that it is important to have some regulation, to have some law to protect children online. Okay, so the provision starts from the beginning, the interpretation section on section number 2, and the definition of online safety or online child protection online starts from the beginning with the definition, and it has been put under child abuse. So you can imagine how it's very heavy. So abuse of children has been put under child abuse, like the general child abuse. So if you have the act with you, I'll just ask you to jump into section 2H, where it says the use or exposure of a child in electronic or online platform for the purpose of prostitution, pornography, and other unlawful practices. So this, you can see, it's expanded than what is provided in the Cybercrime Act. Okay, so this is a bit expanded from what is currently available in the Cybercrime Act. And then the use of child's image for the purpose of pornographic or sexual gratification. Okay, and this is for everybody on Twitter. When you see that person talking and say, hey, who you nezaka? You know, you fill in the blank. You know, I get those posts almost every day. Can you do something about this person? They are saying it can just be a girl. Like now, music festival is going on, so you can imagine from next week we'll get a lot of those photos. You know, and it's just a girl recently dressed in their uniform, or a small girl with ponytails, and someone says some very derogative. That is a crime. That's child abuse. Okay, they don't have to be exposed, but the fact that someone has insinuated some form of pornography or sexual gratification, they're going to gratify by themselves by that photo, just looking at that photo, even if it's a child who's putting on uniform. Dissemination of any material, information, education, or health services that promotes or induce, condone, or normalize sexual activity or behavior among children or with children. Okay, in other words, porn is illegal. Okay, any similar acts calculated to cause physical, emotional, economic, or psychological injury to the child. Okay, so if your whatever activities that are happening online, just weigh them. Okay, are they going to physically harm a child? Okay, it can be an online activity, but it's affecting a child in a physical form, because a lot of people think I'm a Twitter warrior or a Twitter warrior. I mean, I'm a keyboard warrior or something. It's not going to, but if your action is going to affect a child physically, that's child abuse. Okay, it can be that tweet, it can be that Instagram post or a TikTok video. But if it's going to harm a child physically, emotionally, economically, psychologically, that is child abuse. Okay, as I said, now I'm going to jump. Most of these my slides are basically on 20. Now we jump to section 22. From section 2 to section 22, that is, it has a comprehensive. It's the most comprehensive section on online protection. Okay, so the section is very heavy, and it has been borrowed. It was borrowed heavily on the children in the digital environment by the UNCRC. Okay, it was heavily borrowed from that document by the UNCRC, the general comment on children in the digital environment by the UNCRC. So, and it starts, but no person shall subject a child, okay, to, without prejudice on generality of the subjection, any person who, through electronic system, network, or any other communication technology, one, propose, solicit, or meet a child for the purpose of engaging in activities, sexual activities contrary to the provision of Sexual Offences Act. Okay, so if you're going to engage a child, you're using electronic means, that is WhatsApp, text, call, Twitter, Instagram, Snapchat, gaming. Okay, if you are playing a game and you're doing it, it's not allowed. Transmit or cause to the transmitted any obscene materials or otherwise make such materials accessible to children. Okay, so if you're, and this is even at the household level, if you as a parent or an uncle or an auntie or a guardian or a teacher, you have materials on your phone and you want them, and they are being accessible to children, that is not allowed. So that makes it puts the burden to you to ensure that you don't have those materials that can be accessed by a child. Because if a child accesses and you're in your phone, it is you that is who has that crime. In any other way, subject a child to online abuse, harassment, exploitation, whether through social networks, playing online games, or any use of mobile phones or other electronic devices. Okay, trolling. Okay, the next section defines bullying. This means, like, if you're going to troll a child or troll a person and you're causing this harm to them, so that is illegal. So I'm continuing on section 22. I'm just finishing. Commits an offense and shall be convicted and be liable to imprisonment for a term not exceeding 10 years, okay, or fine not exceeding 2 million shillings or both. So that means if you troll and that person is a child you're trolling, that you are in trouble, okay? A person, the reference is subject to section 3C to online abuse includes cyberbullying, grooming, solicitation, cyber incitement, cyber harassment, and cyber stalking. Okay, so it has defined the top one. Like if you're bullying, okay, if you're bullying a child online, which I think is called trolling. Okay, if you're grooming is where a child or a person is made to think they are good, and then for the sake of abusing them. For example, a girl is told, you're so beautiful, look at you, you're nice, okay? And then next time they'll be told, please remove your tops, okay? Next time, can I see the bottom side of your body, okay? That's grooming. And the next time they'll be selling porn on themselves. Okay, solicitation, okay? You go online, and this is something we get a lot on Instagram, where a girl just posted their photos, they were very nice, they were happy at a music festival, or they had gone to somewhere, and then someone goes onto their DM and starts asking them, as you nini, and that's a child online abuse. Cyber incitement. It's the same, you are inciting a child to join. For example, this one also covers betting. Okay, so if you incite a child to participate in the betting, that is cyber incitement, because you're showing them this big thing that they can be able to reach the world by giving you 10 shillings, and there's a child will give you 10, and then you're inciting them for this world that is not there. Okay, and then cyber harassment. Okay, you start abusing this person, showing them their photo, pulling their history, just abusing them, making their life really, really hard online. Okay, and all platforms becomes really bad. Cyber stalking, I think all of us have some form of this. Okay, when you follow someone until it's so, you open many accounts so that this one, they block you, you open another one so that you can follow them. They block you, anybody, you know what I mean, So it becomes that's also child abuse, and it's child online child abuse. A person who intentionally transmits or causes the transmission of any communication through a computer system or network to bully a child, and such communication places the child in fear of death, violence, bodily harm, commits or an offense, and shall be on conviction and be liable to imprisonment for a term not exceeding 10 years or a fine not exceeding 2 million shillings or both. Okay, so in the online space, okay, if you're transmitting stuff that is going to harm this child using computer, and again, you see the way this act continue, it's emphasizing on bullying, because research shows that children, the highest form of abuse online is bullying. Okay, and all of us know the story about the South African girl who was bullied until she committed suicide, just because I think she had worn a sweater that was different, and she was trolled online on Instagram and on WhatsApp, on any social media. She committed suicide, and that is because, and this is not happening, that's not an isolated case, it's something that is happening over and over again. So bullying is something that can put you 10 years in jail. And you can see they have defined bullying includes cyberbullying or use of information communication technology circulated to harm a victim or victims in deliberate, repeated, and hostile ways, contrary to computer and misuse and cybercrime acts. Okay, so if you continue and I can say, as people who act on this, it's something that we have seen a lot of, even the children who are leaving the internet, because the internet, I mean the whole of internet, because of abuse and because of bullying. Okay, and this act emphasizes so much on that. So I'm going to pause there, because the next part I'm going to talk about child participation. So, and then if you have any questions, please put them on the chat box. We'll try to answer them, myself, Katunge, and Anne. So we'll try to answer those questions. So I want us very quickly to answer this question: who is public? Okay, so the next section I'm talking about is also a newish, it's not very new, but it's a newish provision on Children's Act. So it's on child participation, but I want us to talk about who is public. Okay, our constitution is very, very clear on public participation. Okay, and BBI failed because there was no public participation. Okay, so I'm going to read very quickly. Let me see if the charts, anybody has defined public for me. I'm going to skip the questions. I can see nobody wants to define for me public. Okay. So according according to the dictionary, it is a group of people that evolve in response to issues which are important to that individual, to the individuals concerned. However, in our country, we have a group of people who are never involved. And unfortunately, this group is 24 million, okay, of people who are below the age of 18 years. Okay, so there is not clear, apart from now the current Act 2022, there's not clear provision on child participation. I was engaging, a couple of months ago, I was engaging with members of parliament, and they told us, we don't have a way to engage children. There is no standing order. There's no regulation to engage children in parliament. And that trickles down to MCAs and the county assemblies, okay? How do we engage children? And these guys, if 24 million are below the age of 18, if they voted in the last election, the person they would have voted for would have won, okay? Easily, okay? But because this group of persons do not vote, or they don't have the voting power, they are never involved. So lucky for us, this act provides for it. So the UNCRC and the African Charter has very clear provision. I'll read Article 12 of the UNCRC. It says, state parties shall assure to the child who is capable of performing his or her own views the right to express those views freely in all matters affecting that child. The views of the child being given due weight in accordance with the age of maturity. Okay, number 2, for this purpose, the child shall in particular be provided with opportunities to be heard in any judicial and administrative proceedings, and the child, either directly or indirectly or through representative or appropriate body, in a manner consistent to the procedure or rules of the national law. Okay, so in the previous act, the child participation was only provided when it comes to the judicial processes. Okay, that is only that it was provided, but child participation as a public was not provided for. Okay, where me as a 14-year-old want to contribute in the ongoing of developing of the CIDPs, the county integration development plans. I want to go see my governor, okay, Olelenku. I'm not given a chance because I'm below the age of 18, but the Constitution of Kenya recognizes me as a public. And this is because there was no clear law, okay? Our own regional instrument says the African Charter provides for child participation in Article 4, Part 2, and 7, okay? And it also provides in Article 9, freedom of thoughts, and then on Article 10, it goes to protection of privacy, and 12 on leisure, recreation, and culture, 31, the responsibility of the child, okay? The Charter, the African Children's Charter acknowledges that children have a responsibility. But how will that child know their responsibility if they do not know their rights, or they are not given the opportunity to speak for themselves, okay? So because of that, and then at the African Union Charter, paragraph 12, it is a whole section on youth and child participation, okay? That which is missing in our Constitution, but as Anne will tell us, Article 53 covers it, okay? In the best interest of the child, it covers it. But for the best thing, this charter, the Children's Act came and covered that. So you can get all this information. You can check the African Union Child Participation Guidelines, and it has a lot. It gives all these details. So what are the provisions on child participation in our current act, the 2022? Let's all jump to section 28 of the act if you have with you. It is right to assemble, demonstrate, petition, and participate in public life. So you can see even from the margin, it says that a child has a right to assemble, demonstrate, petition, and participate in public life. It recognizes a child as a public person who needs to be involved, okay? So in 28:1 says, every child has the right to peacefully and armed to assemble, demonstrate, or present petition to public authorities and to freely participate in matters affecting children through local established forums, associations, assemblies of national and county levels, okay? So this, for me, is how can we, the new regime of leadership, how can we enforce this particular provision? Okay, you can see it's national and county. Okay, national, DCS and our friends are going to do an amazing job, but at the county level, how are we going to ensure that participation at the county level? Okay, part 2, the right of a child to assemble, demonstrate, present petition, and shall be subjected to the rights of others. So children can be able to demonstrate, okay, and present petitions. I've had where people say, no, children cannot be able to participate. Their work is to go to school and read, okay? But but if you look at our history in Africa, for example, you check. If you go to our history, for example, the Day of the African Child. The Day of the African Child started because a group of children decided we have had enough. Okay, let's go demonstrate. Okay, and that demonstration it bear fruits. We are bearing, some of us who are not South Africans are bearing the fruits of children going on the streets and demonstrating. Okay, in addition, to the rights guaranteed under subsection 1 and 2, every child shall have the right to express their views in all matters affecting them, and those views had and given due weight in accordance to the child's age and maturity. So I can see this one is borrowed from the UNCRC. So as much as they are petitioning, what are we doing? Are they nice papers that are going to be packed nicely and put in nice frames, you know, or just go and collect dust somewhere? Okay, how can we hold government, okay, and even ourselves policy makers accountable, even, you know, you yourself at your household level, okay, at your household level, how can you hold yourself for those things your child said, hey mommy, I don't think we need to be watching that TV show, you know, which TV show, okay, can we watch something else? And say, hey, yeah, from tomorrow, today is the last episode, and then tomorrow you're there, okay? So how can you ensure that there's that due weight for that, okay? And this is according to child's age and maturity, okay? So there's that so much emphasis on that, on the age. So let's not assume because children are young, they don't think, okay? Me, I work with children, that's my 8 to 5, okay? 24-hour job. I work with children, and when you listen to them, they actually open your eyes and think, why didn't I think of that? Okay. Continuing, the right guaranteed under subsection 3 shall be exercised in accordance to the national values and principles of governance in Article 10, and 2 of the Constitution, be voluntary by a child without any undue influence, coercion, inducement or enticement by any person. And for me, this is one of my very favorite one, okay? Because most of the time, those who work in the children's sector, when you're talking about child participation, it's when an NGO has brought her children and in a meeting, and they tell them, today, we are going to be talking about this. Okay, that is not meaningful child participation. Child participation is when children decide, this is what we want to discuss, these are our issues, okay? And so that's when the meaningful child participation happens. It's not when an NGO or government or someone comes and tells them, today we are going to talk that this is orange, okay? This is orange, but the child they want to talk about this yellow piece in the bag, okay? So for me, for us, that is what, for me, it's one of the most important part in the whole section. So number 5, we are working with NCCS for that, to ensure that we have guidelines for that. Okay. So in child participation, also in the justice system, if we jump to section 222, so you can see in the first part, that part was not provided in the previous act, but this one now is provided in it has been expounded in the current act. Okay, on child participation in the justice system, in section 222, every child shall be afforded an opportunity to be heard in proceedings affecting the child, either directly or through a representative. Okay, and gave a very interesting case before about the way a child got a scholarship, and the dad said, it's not in the best interest of the child. So what that judge did, the judge listened to the child. Okay, what is your view? Okay, do you want to go stay with mommy? Do you want to go stay with daddy? Okay, and the child decided to go to the UK. But we've had cases in this country where the judge goes and sits and says, oh, because the child is of tender age, and tender age sits with parents, but they did not ask the child. Okay, it's not always in the best interest of the child for a parent, for them to stay with the mom. Okay, sometimes it's not the best. So, and that's why this provision is provided for. Ask the child, what do you want? Okay, and it's not only it's both civil and criminal, in criminal justice system. So it has to be in both, not just one. Okay, and then parents and guidance and guardians and fit person have the right to assist the child in proceeding under this act. Okay, you should not curtail, you should not stop the child from stalking. Okay, this act, it provides for that you should not stop the child from talking, and whenever possible, act participate in decision affecting them. Okay, and the emphasis is a decision affecting them unless their participation is not in their best interest. Unless it is not in their best interest, they should not participate. But if it is in their best interest, they should participate. The state shall put in mechanism to facilitate appropriate, effective, let me repeat, appropriate and effective communication with the child in conflict with the law in order to ensure the child participation in the judicial proceedings, including the provision of an interpreter, intermediary, argumentative, alternative modes of communication in appropriate cases. Because we've seen cases where a child goes to court and they're not able to communicate in the way the judge or the prosecutor or his own lawyer understands. Okay, for example, a 5-year-old will more likely communicate by drawing, not talking. So when you ask them what happened to you, they'll probably draw it. Okay, so here this provision, which is an expansion from which is an addition from the previous act, is you need to provide a mechanism on how the child should participate, should communicate in their own way, okay, in their own, where they are comfortable at. Okay, don't force a child to speak English. Okay, if the child is comfortable speaking Turkana, let them speak Turkana. It is your responsibility to ensure that you have an interpreter. Okay, so, and if the child can be able to draw, it's your responsibility to get a psychologist to come and interpret the child's drawing. Okay, so for me, it's so this is an expansion, and it's a very interesting provision. And for me, the act, it's better than it was because of some of this provision, putting children at the center of this act, okay, and not adults. Okay, I think I am done. I am way below my time. I did it within 30 minutes. I think that's because I had planned for 30 minutes. So, Shukran, if you have any questions, I would really appreciate it. Thank you so much, guys.
Wow, just wow. Thank you so much, Jennifer, for taking us through child participation, online safety. And I know there's much more that could have been said. And for those of us who've met me in the corridors, you know how passionate I am about online safety for children. I keep saying that as we make our own advances, where technology supports our work, say at where we work, where we school, where our children go to school, places of worship, we've really embraced technology. But the perpetrators as well are moving with the same speed, if not faster. So we can't ignore the bit on child online safety. And maybe it's at this juncture that we can mention that the government has been making various efforts to try and curb the menace. So we have the National Plan of Action to tackle online child sexual exploitation that will run for 5 years. We have the highlights that we have from Jenny on online safety, where now online abuse is recognized as a form of abuse. We call it a non-contact form of abuse. It's acknowledged as abuse, just like you'd have physical abuse, you'd have sexual abuse. When there's a case of online abuse, it's taken in as just as grave a case as the others would be. We also have the responses. Maybe someone will be sitting there wondering, all this stress. So when we have cases of abuse, you've heard about the law, we've heard about the good people, the government being Anne Thiongo and the CSO. Here we have Jennifer Kaberi. So what happens? We have the government helpline 116, where you can report any concerns of child protection concerns basically. So the government is really doing some good work, I must acknowledge. The CSO is also doing some good job. And I'd like to take some questions. The questions have been so many. So Jenny, as you take a breather, I'll ask Anne to handle some of these questions. A lot of comments are on where can we get these slides. Again, I'll direct you to the Facebook page where this is streaming live. Right after the session, you can always watch it and refresh your mind on it. So the first question that I took was, well, very many compliments from Rashid Mohammed, saying that was a group presentation to Anne. Then same Victor Adula. So someone was asking, how do you determine an intersex child? And the response was given that an intersex child is a child with an ambiguous genitalia and does not show if they are a boy or a girl. So for the sake of our Facebook followers who might not have the privilege of seeing the chat, I had to read that out. Rosemwanda Wiro asks, how do you handle an issue where a mother or guardian uses a child to beg money along the streets? Do you term that as child abuse? And how can one help? And I believe that's squarely yours.
Thank you very much, Joy, and thank you all for listening in, and thank you for your questions. If I may answer to that question, Section 144 of the Children's Act, subsection C, talks about children who are found begging. So I believe under that law, under that section, then that child is a child in need of care and protection.
Are you done, Annie, before I?
Yeah, but
so
I hear so much noise in the background.
If you're not speaking, would kindly request that you mute your microphone, and also from the secretariat, kindly take note of the people who are causing
yes, that child, thank you, Joy. That child falls under Section 144, subsection C, who is found begging or receiving alms, and that means that child is in need of care and protection. Thank you.
There you have it. That's a child in need of care and protection, and being a child protection worker as well. Where do you report? You report to the closest children's office. That's mostly at the sub-county offices, where you find the government offices, formerly known as the district officers place, mahali kwa DC, mahali watu chukulia ID. That's how we easily refer people to mahali mnachukulianga ID. That is mostly, not all times, but mostly, that's where you'll find the children's office. And if you're not able to trace it, you dial 116, it's free, it's 24 hours, and you'll be directed to the closest children's office from where you're calling, or where the child being reported about is situated. So where do children whose mothers are incarcerated and are above 4 years taken to? What care service? Where do children of mothers who are incarcerated and are above 4 years taken to?
Thank you, Joy. These children, like the question goes, will stay with the mother in prison. These are always a wing for mothers who are in prison, but upon the attainment of 4 years, they're expected to leave. So I see the question is asking, where do you take these children? Ideally, they'll go back to stay with the family or some extended family, but at that point, they're expected to exit prison. The Directorate of Children's Services is coming with other stakeholders, is coming up with guidelines on children of incarcerated mothers. So that will go to improve or look into the best ways of dealing with these children upon exiting from prison. Thank you.
Thank you so much, Annie. I believe that question, Victor, that addresses your question adequately. Wakili Shiro Kiniti requests that if you could share the citation of the case on the best interest of the minor who was to travel to the UK. She's interested in the reasoning of the High Court. I didn't quite, or rather she didn't quite hear what the judge said when she was presenting. Kindly, if you could type the same on the chat box or share it with me, I could then pass it to Shiro Kiniti. John Juguna
let me say something, Joy.
Yes, go ahead.
Yes, I will scan it. Maybe it's good to share my number because my number is 0722 417 402. Anybody can reach out to me. There was a very recent article last week, Friday, in the Daily Nation. But Justice Onyango said the best interest of a child is paramount, superior to that of the parents, and it cannot be compromised even in the absence of consultation between parties. Thank you. And he threw out that appeal.
Thank you so much, Anne. I believe Wakili, that's well answered, and also typed the number there in case you didn't get it. You can still follow up with Madam Thiongo. John and another one, I think that's Coletta Kiforo and John Juguna. They ask, is there a problem with male circumcision if consented by the parent or a trusted caregiver? Still on circumcision, male children will not, I think that male children will not be subjected to forced circumcision. This is a great idea. And can you clarify what forceful circumcision means?
Let me take
Okay.
How will this happen?
Particular part. And let me say, because I know I typed that particular one, that particular recommendation came from children. Okay, when you were consulting children, of course should be provided. They said they are forced. Male circumcision, sometimes it's forced. They do not want. They are not explained to the importance of circumcision. It's because you've hit 13 or you're going to high school and then you're told you need to be circumcised. There's nothing wrong. Please take it from here. Okay, I'm not a man, I don't know. Okay, there's nothing wrong. That particular recommendation came from children. They're the ones who said there should be a provision, the way there's one for FGM, but why are boys forced to be circumcised? You find there are communities where they do not circumcise boys, okay? But they go to some places and they are forced to be circumcised against their will, okay? And I think this is where parental responsibility comes in. When you are telling this child, you are 13, you need to be circumcised. You explain to them, this is the reason you are going to be circumcised, because it's our culture, there's a healthy reason. But most of the kids we are speaking to, they did not know the reason. They were, as we were taken to the hospital, we were cut, and there was karimanzinga, little dancing in there, and that was it. They were not explained to why they were circumcised. So that provision, for me, because I know we have fought even with members of parliament, and this is the reason. We put it because children said, let's put it there. And this is to safeguard any child in the future who do not want to be circumcised, okay? But because, and they are being forced, they can easily say, I'm being forced to be circumcised. So that particular provision, and we'll add, but for me, that particular one came from children. It was directly from children. Thank you.
Very passionate about child participation, meaningful child participation. And
thank you, Joy, and thank you, Jennifer. That's a good question. And probably if I never sat in a certain forum, I would not have known how to answer that question. One time I'm sitting in a forum and somebody was giving an example of some community who are not mentioned, where children as young as 13, as young as 14, 12 years are in the morning, a very cold, chilly morning at about 3 or 4 a.m. They are taken somewhere inside a forest in groups. There are those elderly men. They go through some circumcision, which sometimes is done very unhygienically. And some of those children have suffered death through bleeding. And that, I believe, could be some of the reason why that has found itself in the law. So I would answer it that way, that it should not be forced. The child should actually be willing and able to understand why they're going through circumcision. I think we all know it's a stage. It's a stage you're going through. You're moving from this stage to the other, and therefore that is where you're being circumcised. Thank you.
I know if this was a physical workshop, I'm sure this would have been a very debatable topic, especially because it's partly parenting. My video is off. It's partly parenting, and we say parenting has no manual. So how I parent, the community I come from, we circumcise our boys at 3 years. You can do it at birth. Another community does it after class 8. We don't seem to agree. So bringing in the aspect of child participation when it comes to circumcision will be a very lengthy discussion. discuss, sorry. And I'm really glad that we have Jenny here, who's, and anyone listening will be able to justify and say, you know what, the children in Kenya wanted that provision. So a lot of compliments in the presentations. Then there's a question on custody. Allow me to skip that one because our presenters today were not handling custody, but the same can be picked up by through the chat box. We'll respond to the questions later. There's one from Robert Magwabi. I hope I got the name right. Since the Births and Deaths Registration Act, Cap 149, does not provide for intersex children, how is the civil registrar expected to abide by this law?
Thank you, Joy. I think I've done my homework well because I actually had to call Senior Counsel Chigiti to assist in some of this. But yes, he did inform me that the registrar now has a responsibility to put in the structures. I believe if it's the birth certificate, there'll be a provision for an intersex person, or if it's a notification, that will be there. But we wait to see how that will come out because the child is neither male or female. So you're now saying, can we have a provision for that special child? Thank you.
Wow, well answered. Well answered. You really did your homework right. Okay,
Thank you, Joy.
Great. A lot of compliments. People are enjoying the presentations from both Annie and Jennifer. Brilliant presentation. Presentation Anne was quite educative, eye-opener. Jenny, good knowledge. Jennifer, is there anyhow we can assist a child who's experienced online child abuse apart from PSS and prevention? PSS, help with PSS, yeah. Psychological support, psychosocial support.
I work with PSS. So the thing about online, most of it is psychosocial. It's a mental health issue. Okay, most of the abuse that happens for online is mental health, but unfortunately it turns into physical. And that's why I think there's a provision, the provision is there, says psychological, physical, because most of the time psychological will turn into physical. So I will direct you to 116, okay? You can call 116 and you can get counselors, okay? But you can also report if you know a child who is, or someone is abusing a child using cyber online in the online space. Okay, you can report. You can call 116 and report, or 0720116116. Okay, you can call those numbers. So, and if you see any images, the DCI has a portal where you can be able to report directly. So DCI has a portal, and also Communication Authority has a portal where you can be able to report directly if you see a child being abused online. Okay, but if you're 116, it's free. It's not going to, you're not going to spend any money. Okay, 116, just call and say, I am concerned that this child is being abused, and Anne is going to jump into full gear to make sure that that child is safeguarded. Okay, so, but you have, as I said, most of the time it starts with psychological because I am not there physically. It's going to psychological and then it turns into physical. Okay, so a child will be groomed, okay, will be solicited, okay, will be enticed, okay, will be bullied online, and then it will turn, they either kill themselves or start presenting harmful practices like cutting themselves or practice some harmful practices or by themselves. Okay, so but call 116, 116 again. Okay, it's the toll-free line for children. Okay, if you have a Safaricom line, 0720116116, and you'll get help. Thank you.
Thank you so much, Jeannie. I know I'm partially moderator, but chiming in because this is my area. There's the number 116, which is toll-free, as Jeannie has said, and it's 24 hours. There's 0722-116-116, 0722-116-116. That is a WhatsApp number. You can also call it, but that one is not toll-free. We have KSAT. KSAT is KECIRT. KSAT is Kenya Computer Incident Response Team, which is a platform run by the Communication Authority, CA. They take down any content that you abuse. So you just go online, Google KSAT, KECIRT, and you're going to be led to a portal where you can make that report. There's the Internet Watch Foundation, where they give you a platform to report any incidences of online child abuse. So those are some of the platforms that you can rely on to support children. But the one that you basically need to remember, and even you can call them 116. Once you call 116, they link you up to all the rest that I have just mentioned. So I seem to be losing the questions, but are quite a number. Where do you draw the line where parents have separated? That's a Kasudi's case. Allow me just to skip it for the sake of our discussions today. Thanks, John Juguna says play and act therapy can open and spoken world. That has been explained by Jenny, how children express themselves. They may not be able to answer a questionnaire, to answer your questions to the depth that you wish, but they can draw, they can model, and you can get the information from their acts. Agnes says, there's a response to Agnes. There's a policy framework in the civil registration as to how birth registration and ensuing provisions of birth certificates is undertaken for children in children homes and CCIs. Then Millicent Adede says, thank you, Jenny, for the presentation. Very grateful indeed. How do you treat a case where both parents are abusing their children or their child? Both parents are abusing their child or their children. That's for you, Jenny. Mm-hmm.
Yes, I've just unmuted. Thank you so much, Katunge and Millicent. So for me, it's, as I think Anne said something important, the best interest of the child, okay? So that's what you weigh. Is this child saying that family in their best interest? If it is not in their best interest, they are better off removed from that home, okay? So first thing, as again, I'll repeat, 116, or go to the nearest Department of Children office, okay? There is one in every sub-county. You can go and they will come and remove that child from that toxic environment, okay? They will place them into a temporary shelter or at placement, now at least with foster care, they will be placed in a temporary home until they're able to, until a solution is found, okay? Or they are able to get someone else to stay with them. But the best way, report, okay? Do not let that child stay in a toxic and abusive environment. It is not in their best interest. Okay, even if both parents are there, it's not in their best interest. Remove that child from that toxic and abusive environment by reporting to 116. Even yourself, by the way, there is a provision that you as a person, as a, I can't remember, can you remind me, but you as a Kenyan, okay, as a member of the public, you have the right to go and remove that child from that abusive environment. Don't wait for DCS, okay? Because if that child dies, you may not be culpable, but you'll feel guilty for the rest of your life. I would have done something about it, but I didn't do anything, okay? But you are allowed, the act allows you, gives you some power, some responsibility to remove that child, okay? And stay with that child until help comes, okay? The help can come in terms of police or Department of Children's Services, but you have, is it directorate or department? Sorry, we are so used to department nowadays. So you can be able to remove the child, okay? And you are protected by law doing that. If that child, you have evidence that child is in an abusive and a toxic environment. And
yes, thank you, Jennifer. Yes, I agree with you. I may not be able to go to the section, but that is called rescue. That's why you find a child in some situation, there's a bit of difficulty. You're allowed as a person, whoever you are, in civil person, to actually go and rescue a child. And I would equate this to, if you're around a swimming pool and you see a child drowning and you're able to swim, or sometimes you're not even such a good swimmer, I don't think you go shouting for the lifesaver. You actually jump into that pool to save the child. So that is allowed, all in the best interest of the child. You know, it's premised on that you're saving a child from a certain situation. Thank you, Jennifer.
Thank you so much, Anne. The two questions that follow, there's an attendee who is asking, what's the escalation? If they visited the children's office, the sub-county children's office, I'd assume, and they have not received any help, what is the next office that we need to visit? And as you answer that, it's not so clear, but I think Kevin Keitani is asking where a child has been neglected and taken into a children's home. And now the parent probably is reformed, or whatever situation they were going through, they have recovered, or they feel they're in a better place to take care of their child who's already been taken into a children's home. What is the process of getting your child back from a shelter or a place of safety after a rescue?
Thank you, Joy. I will start with the first question. What if you cannot get help from a sub-county children office? We have 47 county children offices. That means we have one in Nairobi, we have one in Siaya, we have one in Kiambu, and they are the headquarters of the counties. So one should not feel like all is lost. You feel free to report. You can make a call. You can move into those offices and report whatever case that you want to report. Then I see, then your second question is about where a child has been put in a home. We recommend that when a child has been put in a home, that placement is done through the court. So if the person or the parent now wants to go and pick the child, again, that will pass through the court, so that we're not doing things the Kenyaji way or just going to pick the child. And I believe the children officer will be able to monitor the parents to see ideally, essentially, that parent has been reformed. So you go through the court. Thank you.
Thank you so much, Anne. I believe we've come to the end of our session where the questions have been answered. And if you feel your question has not been answered, I'll give this opportunity to both Anne and Jenny to give us their contacts, how we can reach them. Maybe for the emails, I'll request that they both type in, but for the as well as the numbers, but for someone who is listening on Facebook, maybe we can start with Anne because you're unmuted. What's your number?
Okay, I typed it in, but 00722 417 402. It's actually somewhere in the chat. Thank you, Joy.
Asante sana. Jenny, I can see you in your email. That's jennifer@mtotonews.com. Kindly give us your number.
I'll give you my Twitter, which you can be able to access. You can access me. I can access anytime. And you can be able to, or my Facebook. My Facebook is Jenny Kaberi. So on Facebook and on Instagram. And then on Twitter, I'm at Dalitso, D-A. I'm putting it on the DALITHSO. You can reach me there, but also you can reach me on any Mtoto News platforms. I'm available and I can be able to reach back to you. Thank you.
Asante sana. This has been quite delightful, informative, educative, enjoyable, and all those nice adjectives. I feel really at home discussing matters children, matters the law. And if we had more time, I believe we would have had deeper discussions. But as we had said, this has been a series. We've had the first, second, third, and this being the fourth has been the last, as had been highlighted by our chairperson, Madam Helen. So mine is to say a big thank you from the branch, and also to thank the Secretariat for standing in and making sure that everything went on well. We didn't have any hiccups. To our many participants who've stayed on, thank you so much for staying in and learning with us, asking questions. For Jennifer Kaberi and Thiongo, Asanteni sana, we can repay you for the time, and then it takes a lot of time just to go through the laws, making references and making them really palatable to anyone who's listening. So anyone who came in late and has not had the opportunity to ask any questions, we kindly request you that you go to our Facebook page. We always have the sessions like streamed, so you can catch up with the first session that we are highlighting the Children's Act, the second one where we were looking at children in conflict with the law, as well as children in need of care and protection. We had the third one with Senior Counsel Chigiti, where we had a discussion on intersex children, and today where we had Madam Jennifer and Anne taking us through various parts, sections of the Children Act 2022. So asanteni sana, and I want to it's exactly 4. I want to say thank you so much. Be on the lookout for similar webinars. We always have weekly webinars addressing different sections of the law. So I'd request again that you share whatever topics you'd love to see us air. You can even suggest the presenters to us if you know someone who's really good at a certain topic, or even a topic that you feel we need to discuss at length. Kindly let us know. So asanteni sana, and I want to wish you a very blessed afternoon. Kwaherini. You can have your camera with your friends and exit at your pleasure. Thank you so much.
Thank you. Thank you, Joy.
Thank you, Joy, for inviting us.
Thank you.
Bye. Karibuni
Bye.
sana.
Bye.